Welcome to the next part of the Scots Law Agent Society seminar on the Regulation of Legal Services Scotland Bill and our response to that. My name is Ian Ferguson. I am a retired solicitor. I have been a continuing member of the Scottish Law Agent Society Council since 1985, so some 38 years. And I've always thought that we have been involved in the politics of the profession. And that has involved discussing the issues of the day, and particularly regarding the area relating to regulation of the legal profession and any amendments to that. I do remember that when I started in 1985, it was Westminster who was in charge of legislation at that time, and there was no Scottish Parliament, and there was just an awful lot of difficulty to get Westminster to find the time to make changes to the law of Scotland. And in many occasions this was done by way of a Law Reform Miscellaneous Provisions Scotland Act of the day. But these times have changed, and now there's a plethora of legislation issuing from the Scottish Parliament, and so we have to be even more up to our game in dealing with the politics of the profession and looking after ourselves as a profession. I've always felt that the Scots Law Agent Society has been able to do that, and I hope that some of you will be inspired to get involved and to make your voices heard and to get in touch with these issues and make them your own and argue. Anyway, now I need to have a look at some of the changes that have been done, and the next section that I'm going to cover are to do with the review body that is being proposed by the Scottish Parliament. There's a section 58 of the new bill deals with appeals to a commission review body, and the present structure is that appeals from SLCC decisions go to the Court of Session, and it's the inner house. That's very expensive, and for that reason very few solicitors have the funds to take the matter there, and it's very difficult to take the thing further, and you really just have to suck it up quite often with the view of the SLCC at the lower level. So at the present appeal structure is the Court of Session, and they're replacing that with an appeal to the CRB, the Commission Review Body. It's a major proposal, but it's a review committee of the SLCC itself. There's no proposal for an independent review committee, which would be a quite different thing. And there's no proposal, for example, to this going to the Sheriff Court instead of the Court of Session, perhaps saving at least some of the expense. Now, we can see that for complainants and solicitors, this has the potential to be very much cheaper, provided, that is, that the costs of the review are borne by the unsuccessful party. That seems fair, doesn't it? This is not provided for in the bill, so it will fall on the solicitor as part of the general or case levy. So again, these costs are being put on the profession with nothing coming from the complainers. This is wholly unfair. It's totally unacceptable. The complainers should lodge a complainer levy equal in amount to the usual case levy imposed on solicitors, and again refundable if successful, because that's fair. Now, following a review, the CRB may make such decision as it considers appropriate, including a decision that substitutes its own decision for the decision to which the application for review relates. And where a continuing commission review body upholds a service complaint or confirms a determination to uphold a services complaint, the review committee may direct that such of the steps mentioned in section 10.2 as it considers fair and reasonable in the circumstances be taken. And it says a decision of the review committee under this section is final. So this is a controversial part of the legislation. It's a major change for appeals formally to the Court of Session to reviews to a continuing commission review body of the SLCC. It has missed out the possibility of an appeal to the Sheriff Court. It's a drastic change. The CRB, as an extension of SLCC, would in effect be marking its own homework without the possibility of independent oversight. We remain concerned in relation to the rights established within Article 6 of the European Convention. We think this would be a regressive measure, as solicitors would, by winning at the Court of Session and these costs falling onto an unsuccessful party, now the whole cost is set to be put on the profession. There's no new provision for that unsuccessful party to pay the costs of the other party and of the SLCC regarding the review. The only appropriate path, we think, would be to have appeals to the Sheriff Court. There are numerous reasons why appeals are held within the Sheriff Court. Firstly, costs are lowered in comparison with an appeal to the Court of Session. Second, it is absurd and completely absurd that a technical complaint should go before the SLCC and an appeal lodged whereby the Commission Review Body, as an extension of SLCC, mark their own homework. Thirdly, the Sheriff Court applies the principle of polluter pays. In other words, the unsuccessful party pays for their expenses. So if it's an unsubstantiated appeal gets thrown out, it doesn't fall on the cost of the losses of the profession itself here.